We're back for another round of unilateral decisions. Thank you so much for joining us. Unilateral Decisions delves into the how and the why we got where we are today in this ever-changing landscape of college athletics and name, image, likeness. Today, we're talking about a 2025 settlement that in essence opened the floodgates for student athletes to start getting revenue shares from their institutions. Today's case, House versus the NCAA. Our duo of former college athletics administrators Joe Nickell and Mike Walsh talk with sports legal expert and college professor Sam Ehrlich to discuss how we got here and what it's looked like ever since. We're back for another episode of Unilateral Decisions. Today we're talking a settlement, not a decision like we have on the last several shows. So walk me through House versus NCAA settlement. What exactly is that from a layman's perspective? We'll wait on the legal side, so Joe or Mike step in. What is this at a very base level?
You want me to go?
You do this.
Am I becoming the official dumb it down guy?
Put it on his lower third.
At the end of the day, the NCAA was getting ready to be on the hook for billions and billions and billions of dollars. And if they didn't settle this case outside of the courts, I think we would have been looking at the cratering of the NCAA as we know it, even well beyond what we're seeing today versus what the NCAA looked like, 5-10 years ago. So what House ended up determining, it gave the schools an opportunity to put, a cap on what they can spend as an institution, giving them the official right to pay student athletes directly. It gave damages back to previous student athlete cohorts that were prohibited from utilizing and monetizing their name, image, and likeness. And there's probably other things that this dealt with that I can't remember or don't even understand because I never thought about it other than in the terms that I just laid out. But that's the layman's House settlement, in my opinion.
Yeah, so it tackled a couple of things, one of which was really NIL stuff that was more or less determined before the settlement. But by the time the settlement came around, it was all about the direct compensation from the university. And House kind of, through the settlement, swallowed a couple of other lawsuits as well that I think Sam can probably touch on better than I can. But they, in seeking this ruling or settlement, it was about, to add on to what you said about the schools are making money. How much of that should the athletes be entitled to from the schools? Not just, so it took it beyond their ability to profit off of their likeness and their marketability and more about this direct relationship with the schools who are making money off of what the athletes bring to the table and how much of that should the athletes be entitled to. And obviously a ton of nuance to that when we talk about different sports and all those things. And so that's where, had it gone all the way through to a decision, it would have been fascinating, but also probably would have just ended things. Yeah. So the settlement left a lot of things still to be answered, and we'll probably get into that. But these kind of blanket decisions about this much money can be shared, and you still have to decide how to share it, who to share it with, all those things leaves a little bit still to be desired, I think. But that's the kind of high level conversation about where this was headed.
Legal expert Sam Ehrlich here. Nobody loves antitrust more than you. So tell me how antitrust law pertains to this particular case.
Oh, Sam, I only love antitrust law because I focus specifically on sports antitrust law. Antitrust law in general is the bane of many law student and lawyers' existences, and I fully acknowledge that, but I do love antitrust. Yeah, and Joe, I think when you said this, they're getting sued for billions and millions of dollars. I think it's important to put an exact number on that. The House plaintiffs in their, what they were pleading was about a little over $4 billion, which is a lot of money. Sounds like a lot of money. But then you also consider the fact that under the Clayton Act, antitrust damages are trebled automatically. So we're actually talking about what they were actually going to receive if they had gotten a total win, which obviously you go to a jury, or it would have been you go to a jury, you go in front of Judge Wilkin and might get pared down a little bit, but it could have been up to between $12 and $16 billion, which is a lot of money. It probably would have bankrupted the NCAA, probably would have ended things just like you said. But it was based on two different claims. It was based on, or at least the initial House complaint was based on two claims. First was the barring of the NCAA of athletes being able to profit off their name and likeness, which, Mike, as you said, was basically resolved by the time we had the settlement down. It definitely impacted some of the back claims, considering that the lawsuit was filed in June of 2020. And so you had a year of athletes, and more than that, because you have a 4-year look back period under the antitrust statute of limitations. You had several years of athletes being able to say, well, the damages I should receive, I should receive damages based on not being able to profit off my NIL before it was, allowed by the NCAA at gunpoint in July of 2021. So that was one component, but the much bigger component, much more impactful component, was the second claim, which was that the NCAA, the conferences, and the member institutions were all engaged in a entire price fix of broadcast rights, of broadcast NIL, of, you are showing, we athletes, you're showing our faces on these broadcasts on Fox, on CBS, on ESPN, and we're not getting a dime of it. And the question of whether athletes have a property interest, whether they have an intellectual property interest, whether they have a right of publicity interest in broadcast NIL was still to be determined. We had a decision back in 2016 by the Sixth Circuit that said, no, there's no broadcast, or there's no broadcast NIL. There's no publicity right to that. But Judge Wilkin, in a decision she issued 3 days after Alston, which, the timing was probably not an accident at all. 3 days after Alston, she had issued a decision denying the NCAA's motion to dismiss based on that ground, saying that, well, it actually doesn't matter whether they have a publicity interest or not, whether they have this property interest or not, because what matters is, are the schools going to pay for it? And I think in 2026, we can pretty confidently say, yes, they are willing to pay for it. So we had these two claims, and with the NCAA losing all these different lawsuits, losing Ohio, losing Tennessee, losing Alston, made, I think, the justifiable decision to say, let's try to kind of wrap this all together. Let's try to create one omnibus settlement that really tries to cut off litigation, antitrust litigation, for the foreseeable future. Clearly, they were not entirely successful in that goal, but they were able to get a very broad release clause to, kind of the specific breadth of it still to be determined to a certain degree. But they are able to stop a lot of the litigation, at least by players, over things that are contained within the House settlement.
Well, one, like you'd mentioned that, athletes weren't getting anything from the TV broadcast rights. They deserved more than they were getting, but they were getting scholarships and cost of attendance. Sure. And they were benefiting from being, collegiate student athletes and having their NIL used on TV broadcasts. Was it enough? As you've seen today, absolutely not. But two, this feels like a placeholder settlement. And you said, the antitrust challenges and all that. What's funny to me is some of the challenges right now, and they're more public challenges, they're coming from conferences and schools who are already coming back and saying, you gave us this framework, but it's not enough. And I think everybody that looked at House right out of the gate said, you have arbitrarily set this $22.5 or $20.5 million cap and did not negotiate that with anybody. But now it's not even the athletes that you're hearing from that's saying that's not enough. It's the schools and the conferences saying this needs to go.
Well, it's kind of funny you say that because the way the settlement actually worked, it is kind of a quasi collective bargaining agreement. It's a kind of a quasi CBA between the NCAA and the Kessler and Berman team, which includes, of course, to a certain extent, they actually might push back on this a little bit given some of their public statements after, but the representative lead plaintiffs of Grant House, Sedona Prince, all these different players who are kind of involved with this lawsuit. And the problem with a quasi CBA is that it's not a CBA. Mm-hmm. So it insulates, through the release clause, which, I think, for example, there was another case. Really, House settled a trio of lawsuits. It settled 3 different lawsuits. It settled House, including the amended complaint, which included, which last minute, literally the amended complaint that was filed alongside the settlement added a claim for scholarship limits. Saying that scholarship limits are violation of antitrust law, which allowed the NCAA to kind of fold in roster limits into the House settlement. It also included Hubbard, which was looking at back damages for players who didn't receive Alston payments, but more critically, Carter v. NCAA, which is this interesting little case that really, was filed by the same attorneys and said, well, if you look at the entire NCAA amateurism system, every single amateurism, restriction out there is also violative of antitrust law. And it's kind of clear in hindsight that Carter was filed with no intention to really litigate it because, the NCAA never responded to it. It was just kind of folded into the settlement, much to the chagrin of, other attorneys like those who filed the Fontenot case, which was based on kind of similar claims. Definitely some objections there, but yeah, like it's allowed for a much broader release clause that continues to, insulate the NCAA from a lot of different claims in a way that's kind of similar to the non-statutory labor exemption, but definitely doesn't cover the same kind of ground as we've for sure seen.
So I do have to ask, this is all about the NCAA, right? But its member institutions are following this. Lawsuit gets filed. It doesn't get resolved until much later. So the member institutions are paying attention this whole time. What's happening at these member institutions as they prepare for this? Is this something they welcome the settlement? Are they afraid of the settlement? What's happening at the ground level while this is all about to be decided?
I certainly can't speak for every school by any means. I think there was an acknowledgement that there was going to be some form of what we now call revenue share, some form of direct athlete compensation. What it looked like, who was going to be eligible for it, I think all of those things were kind of on the table, and that's where I go back to where I talked about previously, that it didn't really answer enough questions. And I think that's part of the reason we see some of the strife right now is, I think, to your point, schools were preparing to kind of be told what to do. And I don't think it all the way got there. And so we've got this number that is pretty arbitrary. And I think to your point about schools being the ones who are kind of pushing back, you've got 22% of this bucket of revenue line items. Where 22% came from, I guess, backroom decisions. I
can actually answer that. It was created by, through a model by the plaintiff's expert economist, Dan Rasher. It's the 22% is intended to kind of supplement what athletes are already receiving, scholarships, all the other ancillary benefits. So it's that plus the 22% equals 50% to look at, because professional sports CBAs are generally about 50-50.
So that 22% figure, when you multiply it against the revenue buckets that are considered here, which is, I may miss one here, but TV rights, conference distributions, bowl game distributions, sponsorships, ticket sales, game guarantees, those numbers, when you take an average at the P4 level, it's not representative. I mean, those numbers are crazy to where Texas's numbers, if you put 22% on that, is more like 70 million, 75 million that they should be sharing in this model. Obviously, there's plenty of reasons not to do it that way and not to go school by school what you can share with your athletes. But it also puts you in a position where, and these aren't P4, but just a quick look at the Knight Newhouse numbers for Mountain West, for the American Conference. If you do 22% of their buckets, at least for the schools who are public and report, for the Mountain West, it's like 5 million that you would be sharing. And for the American, it's actually smaller. It's about 4.2 million that you would be sharing. But now you're saying, well, everyone, if you opt in, you've got a $20.5 million bucket and you can give it to these athletes or these athletes and you kind of figure it out. And then the roster limits, which I'll save that for later, but there wasn't enough direction, I guess, is kind of to answer your question, to where schools couldn't prepare for it. They could not have prepared for the blue ocean effect that this was given, where you just had to go, well, we've got a certain amount of money that we've got to find now through cuts or raising or whatever, because while the calculation was based on specific buckets, it doesn't mean there's no mechanism in place to say that the money has to come from there, right? So now you've got backfilling through donations, you've got backfilling through all these other channels that just kind of makes it more muddy in a lot of ways. The execution of the rule. The settlement makes sense. The settlement is clear. The execution of how you administer the settlement, I think, has presented a lot of challenges.
Yeah, you got some schools with 30 plus different athletic programs. You've got some schools without football. But everybody gets the same pot to spend.
Yeah. And it complicates it when the roster limit piece, you've got additional scholarships that can be given now. And everyone who, as long as you're within your roster limit, can get a full scholarship. That some of that counts toward your cap, toward the 20.5, because it's additional, compensation or benefit than what was given before. And so you may say, oh, we're only doing rev share. And I've heard this from schools. We're only doing rev share with 4 sports. But if you've increased your scholarship limit and some of your other sports, that counts toward the cap number. And so there's a lot of accounting that has to go into it, and to figure out where are you actually going to put your effort, while also being cognizant of where should we put our effort. You mentioned Title IX off air, a lot of things that just aren't really answered yet. So there's still a lot of guesswork.
And this, of course, all presumes that the $20.5 million, that cap is actually enforceable or enforced in the first place, which it seems pretty doubtful. I mean, we're still very early into this whole process. I don't think the College Sports Commission, which is this new entity that was announced about 15 minutes after the settlement was given final approval, clearly something that they made up right then and there. Now they knew about this for months. They haven't really done anything in regards to, they're clearly still ramping up. They're still hiring people. They're still doing all these different things. They haven't done anything in regards to 20.5 million. And they also haven't done anything in regards to, at least publicly, haven't done anything in regards to the third part of the settlement, which was all about, third party NIL and avoiding cap, what they kind of consider to be cap circumvention, where, we have the deals that are not for fair market value or not for a valid business purpose, or I guess they're not calling it fair market value anymore. That's what they originally had in the settlement, but now it's within a reasonable range of compensation, or whatever the terminology is. We still haven't really seen what kind of power the College Sports Commission either has or is willing to exert over either of these two conversations. And that's going to be a big piece of the puzzle here. And that second part of it, what they actually have to begin with, is also unresolved, because, well, one thing about class action settlements that aren't present in necessarily present in collective bargaining agreements, you don't have any kind of real power over third parties. So if we want to have another state attorney general led lawsuit over the 20.5 million or the cap circumvention, or we want to have boosters filing lawsuits and saying this is a giant maximum price fixing scheme, that's that the Supreme Court has held that maximum price fixing is a antitrust violation. In fact, it can be a per se antitrust violation. A lot of unanswered questions as to what exactly is enforceable, what exact powers the CSC actually has, and whether those powers are, just flatly illusionary.
There's so much left to be figured out with this stuff, right? But you mentioned that 20.5 million. For some schools, that's more than their entire athletic department operating budget. For others, that's a drop in the bucket, really not a big deal. But while it's not a one-size-fits-all answer to this, where are schools coming up with this additional money when many of them were not operating at a net positive income for the last 2 decades?
I mean, that's one of the interesting things I think we're going to see in all of this. I mean, to your point, that is some schools' entire budget. So what you're seeing is 2 types of institutions. You've got those that can meet the cap and are trying to figure out, third party opportunities on the outside, to be, quote unquote, above the cap. But then you have others that are not even close to the cap, and they're setting budgets, but then they're never happy with where their budget is, because they're going out and they're trying to bring student athletes to campus and realizing that other schools are paying them 2 or 3 times as much just to be a part of their roster, whereas they might be a starter over here. And so you're seeing these budgets increase, but you're not seeing their department budget increase. So where is that money going to end up coming from? And I mean, shoot, when I started in college athletics, it was in media relations, and we had, 3 full-time people and a GA. And then now you look at these departments and there's graphic designers and, we have more than one video guy and we have, staff writers and all of these things. And this is not at, the top upper echelon of these institutions. This is across college athletics. I legitimately wonder what these staffs look like in a year when they realize that a majority of their revenue, or at least 50% of it, is going back to the student athletes, that are bringing revenue into the institution.
Well, yes. The argument is that they've got to, at some point, they have to find ways to use that investment that they're now making to drive revenue in ways that they didn't use to drive revenue. Mm-hmm. And yes, there's going to be some schools who just write the check and ask the athlete to show up on time, and that's good enough for them because it's less of a budget impact for them. But for a school to compete, a school that's going to look at that line item and like have a lump in their throat over how much that's going to cost them, just like a startup company who's got to figure out, we've got employees, we can't afford janitorial services. So yeah, part of your hourly wage is going to be cleaning the toilets. And I'm sorry about that, but that's where we are as a company right now. And we're trying to grow out of it versus the corporation that can pay you the same wage to work in the mailroom and you don't have to worry about a toilet the rest of your life. There's similarities here where the school's at a point where 20 million is not attainable for them. And honestly, the 8 to 10 they're trying to spend is a stretch. Those bodies you just talked about, you can cut your way out of it and you can hope and you can just think that winning is going to solve some issues, and maybe it will. Or you can try to actually monetize the rights that you now are granted by paying the athletes. So you're making a choice to pay the talent, and the talent is not only on the field, but also their publicity rights and everything else that goes into, all the things that the schools were already doing. You got all the scheduled posters around town, everything, right? But now multimedia has exploded. You've got your sponsorship groups. You've got all these other things that you're basically, the school is in a position where when they all started selling off their multimedia rights to Learfield and Playfly and JMI and all these others, it's the same thing that those groups were doing. Those groups were coming in and saying, we value this school's media rights at X. We're going to pay you this guarantee. And now it's our job to go monetize it. And frankly, that's what the schools are doing with athletes now, whether they see it that way or not. They're choosing to say, these athletes are worth this to us. We have to find a way to monetize it. Some will be able to monetize it. Tennessee, they can raise ticket prices by a couple bucks. 100,000 seat stadium, 110,000 seat stadium. You drive in a lot of that back. You can start to figure some things out that way. Other schools that don't have the same lever that they can pull, you got to figure something else out. You got to find a way. How are we going to monetize what we just decided we were paying for up front in a lot of ways to go activate? And honestly, it's going to be some of those people in the department that you're talking about. Some schools are going to choose to cut. Some schools are going to have to look at it and say, this is how we're actually going to make money off of this. And it becomes a revenue, a profit center, at least to enough of a degree to offset some of the expense. And so that's where this is all leading to, that I think because of the way college athletics has been structured for so long, it has really been, a lot of people have said college athletics doesn't have a revenue problem. They have a spending problem. And that has to flip at some point. It has to flip that you think about how do you monetize the things that you do have the rights to, instead of just thinking that, well, when we're happy, everyone else is happy. And when everybody's happy, we can ask them for money. And the university wants us to be really successful, so we'll get subsidized there. And the state wants us to. That's a part of it. It's part of the equation, no question. But if you're going to increase your budget that much in an expense that you've never had before, you got to find a way to recoup it.
Well, and that's, the schools are going to have to make a decision. Like those that are not at the cap, like they've got two options. One, take those rights and try to monetize them to recoup some of them. Or continue down this road right now where we're going to give you this, but we're also going to try to add over here and here and here, so that it's actually going to be more than what it looks like today. And that's the conundrum that they're in right now. Like they're competing with schools that can pay a lot more, and they're saying, yeah, this is your contract, but we're going to try to get you more over here. And you're right. They're going to have to make a decision.
How does one utilize those rights as an institution, right? Because you talk about some places are just going to be like, you come here and play, that's good enough for us. Historically, head coaches don't like sharing time with their student athletes. So if if the answer is the student athletes need to do more than just show up and play the games and be at practice and remain in good academic standing, how can their rights be utilized to gain income for the schools when you've got pushback from the coaches saying they don't have enough time to do anything more than they're already doing?
Mike Walsh is one of the best people to answer this question in the country.
So that all has to be considered up front. Like, that's the simplest answer, is that just like any other situation where you go into business, your organization has a sales plan, you have a revenue plan, you have a budget, you have a P&L, you have all these things that you have to be honest to and you have to listen to. And part of that, when you go sign a quarterback for twice as much money as you budgeted, you better know darn well how much time you are getting back from that person in order to activate the rights that you're paying for, or you've got another way to do it. Again, I'm not the one who's going to sit here and defend like the donor side of this. And I would love to get into a longer conversation later about taxes and people getting, charitable donation stuff for their ability to contribute to revenue share buckets and all these other things. But for the purpose of today in this conversation, you have to know what you're getting from that athlete. If you are not willing to say, this is the amount that we can go up to in order for you to basically do nothing, show up and play sports. And if you want to go above that, this is what we need from you in return. And that goes all the way around. That's not just between, a general manager and the athlete. The coach has to be involved in that. The position coaches, quite frankly, some of the people who in the department know more about academic thresholds and the time commitments that go into that. Like, what are you reasonably asking for out of somebody? And then you have to map it out. You have to say, these are the 6 weeks in the spring that this football player has the most time in their day, and we're going to make sure that we schedule these activations for these dates. You have to leave room for some organic stuff, but you've got to have a plan. If you're going to go sign somebody to a contract and you don't have a plan for how you're going to recoup that money, if that's important to you, again, caveat, like there's schools that it's not. I get it. But for the schools that there are where you want to recoup some of your investment that you're putting into that, you got to have a plan. And you have to treat it like a business in a lot of ways, and everybody has to be on board with it. You don't get to say, you make concessions all over the place. If you're going to say this quarterback, we can pay $1 million, he needs 3, that delta for us to pay him an extra $2 million, and coach, for you to have him on your roster, this is what we need. We need to make sure that we have this time from him. We need to make sure that he is involved in these public opportunities and this photo shoot and whatever else. And these are the weeks we need of him. If you get 3 months into that agreement and all of a sudden that athlete's not available for those things that you had agreed to, what else? Where else? How are we making that up? What are we doing? A lot of decisions you can make there. You got coaches who are giving money back at this point, right, to their schools. Maybe that's part of the conversation. But you got to make a choice, and you have to have a plan. And I keep repeating it because it's crazy, because I don't think many people do. Frankly, the conversations I'm having is that, well, we signed this athlete to this amount of money. What do we do with it? And it's not contemplated in the contract. And there's not a plan going into it to say, this is what we could afford. We stretched our budget to this, which means we have to make up for it with this much more net profit, net income. How are we going to do it? And a lot of other people in the world have to figure that out in their line of work. It's time for college athletics to start figuring that out.
So, Sam, I want to go back. This is something I think Mike mentioned last episode, but the idea of pay for play. If I'm casually observing this, to me, this in essence allows pay for play. Why is that accurate or inaccurate?
The only reason it's inaccurate is because the NCAA and the school's contracts and all this doesn't call it pay for play and explicitly disclaims it being pay for play. But the reality of the situation is that it's pay for play. It really is. I mean, you can call it revenue sharing. You can call it broadcast NIL rights. You can call it broader publicity rights. It's pay for play. The reason why Miami is willing to shell out more than $10 million for Darian Mensah is because he's a really good quarterback and he's going to make Miami's team better. It's not because he's, a really good face for commercials. I'm sure he is. Like, he is, I'm sure, but that's not why they're paying him that amount of money. But that gets into the employment conversation. That gets into the kind of this, the scary kind of, monster in the closet for a lot of athletic administrators, which is the employment conversation, and the Johnson case, which is another case that we haven't really talked about, that contemplates the idea that college athletes are employees. And the issue that I think we're dealing with at this point is the only reason why college athletes are not considered employees is because the court hasn't declared them employees. And the only reason the court hasn't declared them employees is because they haven't gotten to it yet, because Johnson is still at the motion to dismiss stage. Third Circuit just came back in July of 2024 and said, this test that the district court used previously wasn't the right test. We're going to create this new test that's actually significantly broader and significantly easier for athletes to meet than the GLAD test, the internship test that the NCAA had insisted on before. As well, they preferred a no test. They preferred just saying, just looking at the historical context relationship. District court wasn't buying that. Third Circuit wasn't buying that. But then, the 3-0 decision, the Third Circuit said, no, actually, I mean, some athletes are employees. The question is how many of them. And I think at this point, like, it's not a matter of if, it's a matter of when. It's a matter of when we have a court look at these contracts, look at all the reality of the situation now, and how we've even gone well past, because, like, if you look at the Johnson test, for example, the fourth factor, which is the one that contemplates compensation, expectation of compensation is a big part of any employment test, or most employment tests. And it talks about not even just direct cash payments, but also, indirect in-kind compensation, which was the issue in the Dartmouth NLRB decision, by the regional district there, where they actually found that non-scholarship Dartmouth men's basketball players were employees for the NLRA. The only question is, how broad is the employment determination going to be? And players who are getting pay for play contracts, or contracts that are not pay for play but are really pay for play, they're certainly going to be considered employees. The question at this point is just kind of what the reach is going to be like.
Now, we haven't really touched on Title IX, but Title IX, I think at some point will play a role in this.
Yes.
So when we're looking at these schools that are, many of them already losing money, about to lose a lot more, trying to stay relevant, at what point do we realistically see even more cuts to athletic departments, as far as, Joe, you already mentioned staff, support staff, but then athletic programs? When are we going to go from 16 to 25 athletic teams down to 2 to 4? And what's the timeline for potential cuts?
I mean, I don't think it's that far away. And I think that part of it, I talked about roster limits and kind of kicking that can. This is where I want to be able to have that conversation. The example that sticks out to me, and there's many, but you had this shift through the settlement where now there's no cap on the amount of scholarship money that can be dispersed to a given roster, so long as the team is within the roster limit. So, for instance, men's swimming. Men's swimming used to, there wasn't really a roster limit per se. That was all kind of school-based and how they would try to do roster management and fit within Title IX. But you could bank on 30, 35 athletes being on a roster, 9.9 scholarships available. So divvy those out. So that means that you've got roughly the equivalent of 20 to 25 athletes paying to go to school to be a part of this team. Obviously, there's other expenses, but that's a consideration for the university for why they would sponsor men's swimming. Now, all of a sudden, you can still do that because there's no requirement through the settlement that you pay full scholarships for everybody on your roster. You can still have walk-ons. But if you want to be ultra competitive, if you want to be at the highest level, you're probably going to reach your roster limit, which is now 30. You're probably going to put most, if not all of them, on scholarship. That's a completely different calculus now for a school who has sponsored all these sports, that sports were a way to attract certain students, not even just athletes, students who, and I'll sit here and continue to defend athletes forever. That's why I got into college athletics. Disciplined, hardworking, understand a lot of time management. They're typically very high achievers. These are students that you want in your university. This was a pathway to get a lot of them in, and many of them paying, or at least, maybe getting grants, maybe getting other types of scholarship funding because they're such high achievers outside of their athletic capabilities. Those are starting to erode a little bit. with this roster limit construction that allows you to pay full scholarships to all of the athletes on a roster, that if you want to be competitive, that's the decision these schools are going to have to start making. Are we trying to be competitive, or are we trying to field a team? And that decision-making process has been in place for a while, but now you've got this extra consequence of like, well, if we want to be competitive, it's not just building a facility, it's now paying out for these scholarships and reducing the amount that the university has coming back to it, to where athletics just continues to be a cost center for these universities who are asking, what are we getting in return? And there used to be some easier answers that I think are getting a little bit harder when it comes to some of the sports that are not considered revenue sports. And you've got to start making those decisions. And I think that, you know, for the schools that are in the middle of trying to compete at the highest level in football and men's basketball and women's basketball, and they're spending that $20 million and they're looking and going, indoor track just got a lot more expensive for us because these scholarships, in order for us to compete for a national title, which we used to hang our hat on, we've got to pay for them. It's not athletes paying us. And it's just a completely different calculus right now. And I think that it's just a matter of time before we start seeing some schools of consequence make that decision to move away from some of these sports, and how that impacts Title IX and their ability to stay compliant with those federal regulations. It's a major talking point.
I think you're probably going to have that framework built out in whatever future iteration looks like in college athletics. Like Mike's talked in the past about this college sports model. Like, we're going to go away from the term amateurism and just, this is college sports. And as they develop the framework for college sports, I think they're going to have to build in, like the NCAA has now, like to be an NCAA athletic program, you have X number of sports. And to protect some of these programs from what Mike's talking about, that's going to have to be built into, whatever this next iteration looks like.
Yeah, and on the Title IX question, there are three ways that Title IX impacts the House settlement, impacts kind of the future kind of implications of the House settlement. At least two of which get really, make things really, really complicated. The first one that has potentially less of an impact is calculation of back pay, the $2.576 billion that the NCAA is paying, and the Power Four conferences are paying, or Power Five, because Pac-12 is part of that, are paying to the to previous athletes. That's currently under appeal based on Title IX. The calculus of how that $20.56 billion is going to be paid out is overwhelmingly to men. About 95%, more than 95% of it to men, because it's mostly football player, men's basketball players. There are the objectors and those who have appealed to the Ninth Circuit are saying that actually has to consider Title IX, because the NCAA would not have been able to, or schools would not have been able to, pay out athletes, overwhelmingly to football and men's basketball. I don't necessarily know if that's going to go anywhere, just because, when we're talking about these antitrust damages, it's an antitrust calculation. It's not a Title IX calculation. That's what Judge Wilkin ruled, at least. And there's so much deference when it comes to approving settlements that I don't know if that's necessarily going to change things, but potentially, you never know. Title IX was clearly not designed for these kind of calculations. So that's one thing. But the second and third ways that Title IX impacts things here make things really, really complicated. Because the second one is, of course, not looking at the back pay, but the forward pay, the revenue sharing, this $20.5 million cap that schools now have to spend on athletes. And there's an open question about whether that $20.5 million has to be split evenly between men and women on campus. And nobody has an answer to that. I can tell you, as the associate editor of a sports law journal, a few weeks ago, we got two submissions on back-to-back days, one of which argued strenuously that the revenue share calculation does have to comply with Title IX, and one argued strenuously that the revenue share calculation does not have to comply with Title IX. So we just don't know. We really just do not know, because, again, Title IX was not designed for these kind of conversations, and whether direct payments constitute the type of support that has been kind of interpreted, open question. But the third area is kind of what we're talking about here, which is the cuts. And when we're talking about cutting sports, with cutting women's sports, there's a really, really powerful calculus that's in play here, which is the fact that if you cut a women's sport, prong 3 of the Title IX test, there's 3 prongs to the Title IX test. You only have to meet one of them. Prong 3 basically goes away. That's what courts have overwhelmingly decided since the Cohen v. Brown University cases in the 1990s, where, for example, San Diego State just had to settle a lawsuit because they cut their women's rowing team, and the court said you violated Title IX. Well, the court didn't say, they settled it, so no. They did. It survived motion to dismiss. So the court did say probably, but that gets into the weeds. But yeah, Fresno State also settling a lawsuit. We do have potential of that changing. This 3-prong test was not created by a court necessarily. It was created more by the Department of Education. The Texas State Attorney General, when defending Stephen F. Austin in one of these lawsuits, is saying that, this test does not survive kind of the different level of getting real deep in the constitutional law waters here. But basically, there's been Supreme Court cases that kind of call into question whether courts have to rely on this test. I don't think that's really going to go anywhere. It's an interesting shot. There's also one interesting thing about the House settlement. Kind of notably, if you look at the long list of kind of these different roster limits and what the new roster limits are for these different sports, cheerleading and stunt are included in there, which is an interesting kind of conversation, because if you look back to Bettinger v. Quinnipiac University back in 2011, 2012, the Second Circuit said these are not part of they're not NCAA sports. They're not considered. They don't count towards Title IX. Could that be changing? Could that be something where there's going to be movement to try to consider stunt and cheer towards Title IX? That could change things as well, and could maybe kind of assuage from a Title IX perspective some of these cuts. We just don't know at this point. I think there's a lot that needs to be answered about Title IX and really how it impacts this new collegiate model, because we also don't know, like, even if we do have collective bargaining, what the impact of Title IX will be on there. If, for example, we have collective bargaining for football players and men's basketball players and not for women's sports, how that's going to affect things. So many unanswered questions.
Closing thoughts on House versus NCAA we didn't get into before we get to our unilateral decision of the day.
My question kind of goes back to, and this is for Sam, this goes back to the employment piece and, collective bargaining and Title IX rolls into it and treating everybody, the same. But if football is pulled out of this, from the CFP, which is something that we've talked about, what we've seemingly agreed on is that whatever the NCAA looks like in its next, iteration, that would include men's and women's basketball. If that includes men's and women's basketball, I don't know how we treat different programs differently. Like, I think you'd have to treat men's basketball the same as soccer and softball and all of these other things. And if all of that's kind of roped in together, would they not be the same? Like, we could pull football from this if there's another model, but are we going to have to also pull men's basketball and women's basketball together out so that, or are we looking at a model where the NCAA is only going to be these sports and everything else is club? Like,
I don't really have an answer to that question, unfortunately. It's because, again, we just don't know how Title IX applies to some of these situations. Like, if you pull football out, if you make football kind of its own thing, does that mean that you don't have to have those 105 roster spots for women's sports as well? We don't know. My guess is probably not. It would probably still count as long as they're part of the university, but again, we just don't know. There's still kind of an open question. We currently have the Schroeder v. University of Oregon case, another Title IX case, which is a really interesting one because it's these, their beach volleyball team, which there's no question they've been completely mishandled. That team's been completely mishandled by the University of Oregon. I don't think I'm going out on a limb and saying that if you look at some of the pictures and some of the allegations made in that complaint. But one of the ways that Oregon's defending itself is saying what you're doing in kind of prosecuting this claim, plaintiffs, is you're comparing this beach volleyball team to the football team, and you can't do that because they're just so totally different. Because that's exactly what they do in the complaint. They have a picture of the beach volleyball facilities, quote unquote, and then they have a picture of these beautiful football facilities, and Oregon saying, well, that's not a fair comparison. You can't do that. So how the court rules in Schroeder, I think, is going to be an interesting kind of question, answer to that question to a certain extent. But and I go back to kind of my original point about Title IX. Title IX was not designed for any of this. Like, Title IX has been stretched so far at this point, and we just don't know how courts are going to answer these questions. And I'll be interested to see for sure.
Okay, unilateral decision time. We'll start with Joe. If you were in charge of college sports, how would you resolve the unemployment question as it relates to student athletes and the universities they represent?
Man, I don't know, which is not good for the name of this show. I mean, I question whether, if you hear people saying that it's good for the athletes to be employees, and then you hear it's not good for them to be employees. And I was an employee and I didn't have to go to school. Like, do athletes even have to go to school if they're officially considered employees? And then if they're considered employees and they don't have to go to school, does that take some of, the glitz and glamour off of what Sam's talked about in the past about how, part of the draw to college athletics is that, like, they're a part of your institution where you went to school and you were sitting in class with this guy and this guy and this gal. And, so I really don't know the answer to that. I think whatever parameters you can put in place to develop a framework where they are monetarily benefiting from what they are bringing to the institution and taking care of them from a health perspective and giving them something that they're going to be able to carry with them long-term beyond just a degree. I'm in favor of that. I don't know if that's employment. I don't know if that's, coming up with this college sports model. I don't have a good answer.
That's a nuanced, undecided decision is what that is. So, Sam or Mike, can you provide us with a unilateral decision here?
Well, first of all, I do want to say something. When I was a doctoral student at Florida State, I was an employee of the institution, and I still went to class. There's nothing in employment law that says you can't also be a student at the same time. It's very common at schools. And I think that just goes to there's a lot of misnomers about what it would mean for college athletes to be employees, and a lot of misinformation potentially. And it's not to call you out. It's what I see all over Twitter or X or whatever we're calling it these days. It doesn't mean that athletes can suddenly be, fired at will, just in the same way that Jimbo Fisher can't be fired at will unless you have $75 million to pay him, or however much it was. Employment contracts are still a thing. At will employment only survives as long as the employment contract says differently. And, I imagine it's going to be the same for, these revenue share contracts if they are, or these employment contracts if they eventually turn into that. So I just want to get that out of the way. Kind of, again, a lot of this misinformation about employment status and what that means. It does mean that schools will have to incur a lot of expenses with additional benefits, all these different things that I'm sure by the end of the semester, my HR law class will be able to tell you all about. We focus so heavily on what it means to be an employee because it is a magic word. It is a magic word in the legal space, being an employee versus an independent contractor or any kind of non-employee. And I think schools have to get ahead of it. I think the NCAA has to get ahead of it. I think they need to start planning. If they're not planning now for an employment model, they need to start planning now for an employment model. Because like I said, it's coming. It's not a matter of if, it's a matter of when. And it's also a matter of the scope of it. And I apologize in advance. It's a bit of a gruesome metaphor, but I think the best way to think about the employment conversation right now is kind of as an infected limb, where you kind of just have to cut it off to a certain point. Because right now, I don't think it's questioned. I don't think anyone can question that. Certainly Power 2 football and basketball players are employees. Probably Power 4, definitely. Probably even go into FBS. All the different things. Like the top levels of revenue, and employment isn't based on revenue, so that's not part of it. But looking at the test that the Third Circuit developed in Johnson, they're absolutely employees. But you can get ahead of that and say, well, we're going to consider these players employees, and we're going to make sure that these players who we don't want to be considered employees for whatever, for all these different reasons, because they're, Division I, AAA, soccer players, we're going to make sure they're not considered employees under this test, or we're going to take action to kind of insulate them and kind of do it this way. I think that's what needs to be done at this point. I think you need to acknowledge the fact that at least some of these athletes are employees and treat them as employees, while making it very clear, don't let the courts, don't let the NLRB, don't let these outside entities decide who are employees and who aren't, because we saw with the Dartmouth decision, they're going to draw a very broad net. The definition of employment under federal law is one of the broadest definitions in the entirety of law. Like the definition of employee under the FLSA, again, my HR law students would be able to tell you very well, is anyone who is employed by an employer, which gives so much latitude to courts to decide who is an employee. And I think, again, you need to get ahead of it. You need to say, these athletes, we're willing to consider them employees. These athletes, we're not going to consider them employees. And we're going to take steps to make sure that you agree with us. And I think that's what needs to be done at this point.
I think the important thing is that the fact of whether or not an athlete is an employee is not predicated on the presence of an employment agreement.
Exactly.
There's so many more components to it that dictates, in a lot of ways, they already are employees. And that doesn't mean they're not going to school. It doesn't mean, right? So there's all those things that go into it. And for me, if we want to have this conversation about some sports that shouldn't be employees, that's fine. Stop treating them like employees. Stop telling them when they have to be somewhere, how often they have to be there, all the different things that go into that. Even if you're paying them as under rev share, if you're paying them as an independent contractor, which is what these guys all want, then they should have a lot of control over their time, over how they do their job, over when they do their job, all those sorts of things. That's how it works in the world. There's a lot of these employment tests. You mentioned they're very broad, but employment is not a matter of whether the school wants to say, we want to have you under an employment agreement. Employment is more a matter of the school wants to say, this is how we want to treat you.
Exactly.
And right now, and I saw some mockery, a little while ago, there was the 10 conferences that came out with their statement, and there was some commentary around that said, oh, well, most of these conferences are not employees anyway. That's not true. It's true from the standpoint of there's not enough revenue in there for it to really be to pass one of the tests of Johnson of like who gets the most primary benefit and is that benefit enough? That's one test. That's one component of that test. A lot of those athletes are being treated like employees and that they don't have a lot of independent control over how they do what they're doing. And they receive compensation in exchange for that, whether it's in kind as a scholarship or it's, direct or somewhere in the middle with cost of attendance. They're receiving compensation and they're being told how to do what they're doing. And they don't have a lot of choice in the matter. And we talked a little bit off air about, wanting to work at your sport, wanting to play at your sport. And there's some athletes who philosophically, I agree that play is what makes sense. It's what they're there for. It's how they want to be treated. But there are consequences for them if they're not working. And that makes them an employee.
Yes.
And until that changes, which it's going to take coaches, it's going to take ADs, it's going to take presidents, because the presidents are going to be the ones who have to bear the brunt of this when it becomes a university issue, that people who are being treated like employees are not classified as employees, and that's going to be your problem. We had, and you'll remember this, stat crew people, right? Like people who showed up to input stats during basketball or soccer or what have you. These people, it was determined at a university level that they needed to be classified as employees because they were told when to be there. They were given the tools that they had to use to do the job. And it was a very specific thing that they had to do, that they had to know how to do. And they could no longer be independent contractors. And there were different ways that you went about that. They tried to hire them through a firm. And then eventually they became employees of the university, not because they provided some incredible amount of value or the revenue dictated it, but because of the terms of you told them when to be there, you gave them the tools they had to use to do the job, and it had to be done in an exact way. They were an employee. And I think that if schools are going to have that lens on protecting themselves against those things in that capacity, really need to broaden their scope and look at how they're treating these other athletes who, now that they're making money, especially making money directly from the schools, in a way that they have to file taxes on some of this money that comes in. They are independent contractors by all, other definitions
for now,
but they're actually treated as employees. Yeah. And that disconnect is what's going to have to be, it has to be resolved.
If they get to the point where they're able to reframe college sports from amateurism to college sports and collectively bargain what that looks like for each side, is that a way around employment? Or if they come to that agreement, would they still be subject to employment law based on any potential court case that's coming to classify them as employees?
So not only can collective bargaining agreements cannot supersede the Fair Labor Standards Act. So minimum wage and overtime would still have to apply if they're considered employees. And actually, kind of an inverse to your question, under current law and some models, some proposals of federal legislation would potentially change this. Under current law, to have a collective bargaining agreement, has to be employees, has to be statutory employees under the National Labor Relations Act. So non-employees can't unionize. So that's kind of a threshold question right there. And Mike, to your point, I think it's important to kind of consider. We've talked about this Johnson v. NCAA case. We haven't talked about who Johnson is. Johnson, the lead plaintiff in this case, Ralph Johnson, was a football player for Villanova, which is an FCS school. And he, far and away, if you look at the plaintiffs in this case, is probably the closest one we're getting to a Power 4 football player. And the Third Circuit still said, yeah, looking at his fact pattern, looking at the fact patterns of this Fordham baseball player who's also part of the case, or Tulane, I think a track and field athlete at Tulane. Looking at the fact pattern of these players, it at least survives a motion to dismiss that they could be considered employees. They're not automatically precluded from being employees under federal wage and hour law. So again, this could be drawn incredibly broadly, and you're spot on when you're talking about the control. But I will also say that the Johnson case also does contemplate primary beneficiary to a certain extent. It's not as focused on that as the GLAD test was for, the GLAD test for interns that they originally used in the district court. But, the first two factors contemplate, is the university getting a benefit from the athlete, and does that benefit, are they the primary beneficiary in that relationship? So that will definitely be a part of it. And that goes to the play versus work conversation that you mentioned, and that Judge Porter focused on in his concurrence to Johnson. Still a lot to be resolved. And again, right now it is in the hands of a court to determine where that line is. And if I am a college sports administrator, I do not want that decision to be in the hands of a court.
So stop treating them like employees.
Yes.
That's the unilateral decision.
Yeah.
Stop treating them like employees.
That would be a good place to start.
Brilliant. Put a bow on it right there. We've covered a lot of ground so far. We got a lot more to go, but we'll see you next time on Unilateral Decisions.